Okay, perfect. So, like I said, I work for the Jesuit Refugee Service Belgium. So we are an international NGO active in more than 50 countries worldwide, where we accompany, serve, and advocate for the rights of forced migrants and asylum seekers. Each country office has its own focal points within the migration field. And for us in Belgium, our expertise lays in detention. So we're present in detention centers, return houses, and we focus on promoting community-based alternatives to detention by implementing our own ATD pilot. So I divided the presentation in 3 parts. First of all, a short introduction into alternatives to detention. Then I will say something more about the return houses, which is often used as an example within Europe by officials, but also others being or nominating it as an ATD. And then the last part will be about our Plan Together ATD pilot for families. So first, ATD in the legal perspective. Myself, I'm not a lawyer or a legal expert, so I will limit myself to the basics, but fundamental legal overview when it comes to ATDs. So international law stipulates that immigration detention should only ever be used as a last resort and after all possible alternatives have been considered. And the obligation to examine alternatives is implicitly contained within the principles, which are all known, of necessity and proportionality, in order to avoid the arbitrary detention. In this sense, the UNHCR has the detention has its detention guidelines, where they state that detention can only take place after a full consideration of all possible alternatives. There are several references, but most recently in time, it's also the objectives of the Global Compact for Orderly and Regular Migration. So there are 23 or 26, don't remember exact, different objectives where they call upon states to install or to work towards several issues of migration. And there is also one objective, number 13, where they call upon states to use migration detention only as a measure of last resort and to work towards alternatives to detention. And these are important instruments to influence states to comply with this. At the European level, there are also different legal instruments that define states' obligations to first consider less coercive measures. So first of all, states should start with the presumption that a person has the right to liberty and security, as stated and defined by the Article 5 of the European Convention on Human Rights. But there is also quite some case law at the European Court of Human Rights that deals with the obligation to consider alternatives, and more specifically in the context of vulnerable persons like children, or considered as being vulnerable in general. And there are different statements made by the Council of Europe or Commissioner of Human Rights, who also recommends that states should work towards ATDs. Concrete law provisions you can find in the Reception Condition Directive and in the Returns Directive. The Reception Directive allows for detention only on the basis of an individual assessment. If, like said before, these other less coercive alternatives cannot be applied, these alternatives should not be custodial and must respect fundamental human rights of the specific individual applicants. states should transpose these directives into national law. And the return directive specifies then that detention, if these other conditions have been explored, should only be used for the purpose of forced return of deportation. Then specifically when it comes to children, and the picture is actually Belgium between 2018 until somewhere mid-2019, Belgium detained children again in a real closed environment. And this is one of the pictures taken there next to the airport. So when it comes to children, we all know that the best interest of the child must be a primary consideration in any action that the states make in relation to a child. So that's the Convention of the Rights of the Child. And then the committee, the UN committee defines it more specifically and states that immigration detention of children is always contravenes with this principle of the best interest of the child. Again, the UNHCR, they have a very clear position when it comes to children. So for individuals, they follow the last resort principle, but when it comes to children, they should never be detained for the purpose of immigration-related reasons. It should be independent of the status of their parents, and detention, because the detention is not in their best interest. So instead of detention, appropriate care arrangements and community-based programs should be put in place for them and their families when the children are accompanied. So what we have to keep in mind is that the last resort principle does not apply for children. Alternatives to detention is a very broad concept, or is being used in a very broad spectrum, you could say, from going from engagement-based alternatives, where there were hardly none restrictions or conditions imposed. And then you can gradually go to more enforcement-based ATDs towards de facto detention and real detention organized in law. And there are, I put it here, several examples. So residential accommodation and temporary residence permit is an example of an engagement-based ATD. Then you can have conditions like registration or this designated residence. And then at the real end, it's more the electronic tagging, where you can question how much this is a difference to detention already. So we tend to speak from alternatives to detention, and then you have the more enforcement-based ATDs. We use more the alternative form of detention. The International Detention Coalition researched around 250 practices around the world, and they came up with the defined alternatives to detention in a broad definition as being any law, policy, or practice by which persons are not detained for reasons relating to their migration status. And out of this research, they developed a holistic case management model, where for this model, there are two important principles. So these are the red bands on the bottom and the top. So like I said before, the presumption against detention is very important. So the liberty should be the first principle. And working with case management or this ATD model, minimum standards like basic needs, legal advice, information should be in place to enable this process of alternative to detention, where screening and assessment is a very important or necessary step because it enables to identify what a good placement option should be for the individual person. The case management is implemented to work with the individuals towards a case resolution. Then case management, more specifically, what is it? It's actually an individualized holistic social work approach that helps and stimulates individuals with their changing needs and helps them towards case resolution. It's very important to know that this case resolution is open-ended, so it's not only about return. Return or voluntary return is one of the options that can lead to a case resolution. But it can also be that there is a grant of a visa, so a residence permit, or a movement towards another European country, for example, because of family reasons, in a legal way. Yeah, just for information, there is a European Alternatives to Detention network where 7 European NGOs of 7 European countries are involved, where we share our, we all implement an ATD pilot or implemented in the past, and we share our learnings, and we have the objective to build evidence also to use for advocacy and lobbying reasons at European level, but also at national level with the website. And out of this, the different pilots that run, they started, the first one started in 2017. There has been an evaluation report where in general it shows that providing case management leads to growing trust, and it empowers the ability to engage with immigration procedures. People do participate more in their own decision-making process and in relation to the authorities also, and it contributes towards a timely and fair case resolution. But very important also that it has a very good impact on the well-being of individuals. I added, but I will share later on the slides. I added an experience of one of the clients in the pilots. So yeah, then I go on with the Belgian return houses, which actually has been considered as an ATD, let's say, you will see at the end, for a long time, but this is changing. I mean, with an ATD, like really a community-based ATD, that's how the Belgian authorities speak about it also at European platforms. And also for ourselves, we recognized it for a long time as an ATD. How did it all started? So actually until 2008, Belgium was still detaining children in normal and common detention centers, like together with individuals. But yeah, these places were not adapted, and Belgium was convicted several times by the European Court, not because they were detaining children only, but because Belgium was detaining children in places not adapted to their needs. So in 2008, Belgium changed the practice and stopped detaining children, unaccompanied children and accompanied children, and they installed these return houses, which was a huge step forward, but it was only a change in practice and not in law. So until today, in law, it's still possible to detain children. What it's about, so actually it's about individual houses or apartments. They were the former houses that were provided to families of the national police. So two of the 3 sides of these houses, they're actually still very well protected with bulletproof glass and these things, because the police families had to be protected. In total, there are 28 units with it's a capacity of 169 beds. And the sites are spread over 5 locations in different villages, which for Belgian norms are quite isolated. So this is a map of Belgium, and they're all these yellow dots refer to the different sites. And they're mostly in the northern part, but quite away from big cities. Yeah, and this is a picture how they actually look like. So at the left, it's a typical Belgian house, and at the right, these are the apartments. So in the return houses, you find a mix of families, of profiles of families. At the one hand, these are families who are on the Belgian territory already, often for a long time. This can be undocumented families who had never any kind of legal stay in Belgium, or they entered with a tourist visa or with a student visa. But also these might be families who have rejected asylum procedures in the past, and families who applied for asylum, but have to be sent over to other European states due to the Dublin regulation. So it's very mixed. At the other hand, we have families arriving at the airport, applying for asylum. So these are the families, asylum seekers at the border. And they are also transported to these return houses. And officially, they did not enter the Belgian territory. So legally, we have these 2 groups, but more concretely, they're very mixed profiles with very mixed needs. So these houses are not really guarded like in detention centers where you have the official guards, but there are several restrictions of liberty. For example, one parent should always be in the house. So for example, you cannot go with the whole family to a playground for an afternoon. That's not possible. And also everybody should be in the house between 9 in the morning. Between 10 in the evening and 9 in the morning. But okay, they do provide exceptions, for example, to bring the children to school. And if they have an appointment with the lawyer earlier, they can go to the lawyer also earlier. Like I said before, detention of children is still possible in law. So actually legally, the same detention orders and the same procedures count for families in these return houses as individuals in detention centers. So it's the same time frame, the same procedure to appeal. It's exactly the same. And in these houses, they're not guarded, but return officers, officers of the immigration office, are present on the site, and they can enter the houses also of the families unannounced. When it comes to monitoring, we are actually the only NGO who is regularly present in the return houses. So every site is visited by my colleagues every 2 weeks, where we provide social assistance, psychosocial assistance, juridical information, and we monitor both the conditions as the application of the law. But yeah, as I said, we are actually the only informal monitoring body of these places. And what we see, so in general, immigration office placed each year, the last 2 years under COVID. So normally it's around 120 families a year, or 100, even up to 160 families a year. But the last 2 years, it's about 60 families a year, and we see 1/3, so 20 families we met. Yeah, like I already said, mixed profiles, which means that for each family, we need to install an adapted approach. Each family has a specific needs based on their own specific experiences. What we see is that they all uprooted from their familiar environment, either asylum seekers arriving at the border, they still traumatized because they just left their environment, often very sudden, and they find themselves in these quite isolated locations. And we see that for all of these families, they have difficulties to build trust because they had, especially the undocumented families in return procedure, they experience often bad relations with immigration authorities in the past. So you could question if all what we see is in the best interest of the child. We met often very traumatized children due to sudden arrest by the police. So often they arrive at 6 in the morning and they take out children out of bed, or they are at the breakfast table with their suitcase ready to go to school. And then police arrives and they have to immediately enter the police car. They're brought to the police station, and then after some hours, they are brought to the return houses, often not well informed and not knowing what will happen to them and what they have to expect from these places. So this has a very negative impact on the well-being of the children. Lawyers are often not aware of the concrete legal situation, so they think because they are nor bars and it doesn't look like a jail, they forget that it's all about detention, and they forget about the time limits to appeal, and they think that it's not so serious to be there as a family. So we see families who have difficulties to assert their own rights. Then very concretely, we see that access to schooling is very difficult. For children under 12, they have quite some access to school. Most of the time they go to school, but once you're 12 years old and older, there is no possibility to go to school. And this has, of course, a negative impact on the development and the well-being of children. So we concluded, together with another NGO, we made an evaluation, and we concluded that these return houses do not comply with the standards of engagement-based and rights-based alternatives to detention. So we call it more an alternative form of detention. Because of the restriction of liberty, because it's officially and legally still detention. And we see that children's rights are violated when it comes to education. There are no activities foreseen for children. There are the problems of legal assistance. Children are in return procedures are not heard. So their voice and ideas are not taken into account. And actually our position has been confirmed officially by a report of an official commission who evaluated the general return policy of Belgium. So we feel very much supported with this new official report, actually. And because of these observations, and because of our growing knowledge that the return houses cannot be considered as a real ATD, we started to implement our own ATD pilot for families with minor children. So because Belgium did not, still until today, they don't have less coercive measures in place. Return houses are not an alternative, or more an alternative form of detention and not an ATD, and child detention is still possible. So, and these are the reasons why we started this small pilots, providing case management to 15 undocumented families, running from September 2020 to February 23. So we are after midway. what we wanted to do is to demonstrate that case management might be a valuable alternative to detention. We also work towards, or we hope to work towards a mentality shift where that both politics and authorities focus less on return rates and think more about durable solutions. We hope in this way to put and keep on the abolition of child detention on the political agenda. So it's an operational project where we provide concrete case management, but the information we get out of this experience of the case management we use towards advocacy, not only to local and national policymakers, but also to the other civil society organizations in Belgium. First of all, those who work on detention, but also those who support on the ground undocumented migrants. We foresee several criteria. First of all, it should be about families with minors. They should be undocumented and in that sense at real risk of detention. Because we as an NGO, we cannot provide accommodation or shelter. We only accepted families who have some kind of stable accommodation provided. Often it's provided by the support of other organizations, and they also have to be able to provide in their own basic needs. But we see that this is a difficult criterion to it's something that which is actually very unstable in the end. But the most important criterion is that families are willing to engage and collaborate with the case manager, and are really wanting to work towards case resolutions. We try to avoid families with severe problems of public order and with very severe medical or psychological issues, just because for the main reason that we don't have enough experience about these cases. So what that's my colleagues, we have 2 case managers working with the families. So they work, they're gonna explore with all families, all options. So by doing a concrete legal screening and reconstructing the migration history from the start until now, defining also different barriers, why it's difficult for them to return, or why they still didn't evolve in resolving their case. So by analyzing all that, we look to the different possible options for legal stay in Belgium. We explore, when there's no legal stay in Belgium, if there is some kind of legal stay possible in other European member states. And if not, we will start working and exploring if a durable voluntary return is possible. Concretely, we do this by regular home visits. So we don't have a kind of office where the families come, but we are always going to them. First of all, we visit them, we spend time with them, and we build on a relation of trust. And then we work on these different elements, which I said. And this all to empower them and to inform them very well. And so we will never decide for them, but they will evolve towards own decision making about their future. And this case management is actually stabilizing them more, so it enables them to think about the future. But like I said, this is not the only thing we do, and actually we do this to try to get a systemic change, and the whole time we involve the advocacy. So we do not wait to lobby or to talk about a project until the end when we have a report, but by doing, we approach the immigration office. We achieved an agreement with the immigration office to have trimestral meetings to talk about the project and to have a case intervention. So we came to an agreement that in case we have questions about specific cases, we can have this case discussion, and they provide all material and all documents that they have about this family from the past. So this gives us also a very comprehensive view of their legal situation. And we also succeeded to get a kind of informal protection against detention. So we developed a kind of card that families can have with them all the time. And in case they are been arrested, or checked by the police, they can show this. And it gives for them a kind of a safe feeling, so they can be more at ease moving around in society. Short state of play. So from the our goal was 15 families. For the moment, we provided case management to 14 families with a total of 42 children, most of them minors, so 38 minors. We have 5 single parents within this 14 families, and it's curious, but 3 families still have 1 child in the country of origin, which they left behind before going to Belgium. This is an overview of the whole profiles. It's very mixed concerning nationality, but what we see is that there are quite some families who are completely unreturnable, mostly because of statelessness. So this is one of the observations, and we know that we will lobby for a solution for this group. The time they're in Belgium is very different, but half of them are very long time in Belgium, going up to 18 years, which is like very long. Most of them are around 6, 7, 8 years in Belgium. Let's see, we have 3 families who actually stopped the program. 2 of them actually were influenced by national actions of a very large group of undocumented migrants occupying university buildings and going into hunger strike, with the objective to achieve a general humanitarian regularization. So they decided that this way to protest would lead for them towards case resolution and not by having case management. But they're still, we're still in contact, and they're still welcome into the project. But at that moment, we said that we could not provide and explore all options when they are when they choose for this real more radical way to go. With half of the families we are really preparing, we decided that the best option should be a humanitarian regularization, or a family reunification, or a new asylum claim. For the other families, the perspective is still not clear, and we are in a more earlier stage still of the case management. This is not here. These are some graphics. You see that it comes from 1 year until 18 years of stay in Belgium. And the green parts are the period of a legal stay they experienced in Belgium. So most of them were longer undocumented in Belgium than they had a legal stay. Except for 3, because these 7% refers to one individual family. So except of these 3 families, all other families applied for asylum when entering Belgium. So they went already through that procedure and experienced living in asylum centers and became undocumented after rejection. This is an overview of the different running procedures. So some of the first learnings until now is that expectations from case managers and the pilot should be very clear from the beginning. And we should repeats the objective of the case management often. Talking about return as one of the options is very delicate, and we feel that we can only start really talking about it once we in detail explored all the other options, and once we can explain and demonstrate that the reasons why these options are actually no options to stay. Case management should be tailored, but for families, it's really very, very specific, because you have to deal with the internal dynamic of each family, which is very different. You have families where the husband is the spokesperson. You have families where the children take the lead, actually, because they have to translate. You have families where children are very much aware, but other families where the children don't know anything of their legal situation. So you have to deal with all these differences. Families are quite well supported by their environment, but in order to provide these basic needs. But what we see with all families is that they have a lack of social juridical support, specifically the juridical support. So case managers are mostly working on the legal part. Key is a good collaboration between the case manager and the lawyer, and that is really a big challenge, because we have one issue now that we are thinking about: what can we accept as a reasonable time that the lawyer needs to work on a case. We really have to lobby and push the lawyers to introduce, even they also think that a procedure for regularization is the best option. We really have to lobby, because 6 months later, the case is still not, the lawyers still didn't apply for this regularization. And actually the case management is a kind of blocked in that way. So the evolution is blocked because the procedure is not started yet. So it's not only about building trust towards the families, it's about building trust towards authorities, but also towards lawyers, and explaining them the objective of the process. It's a long process because of these issues also, but also because a lot of external factors are involved, and one of these factors can be the accommodation. So we had 2 families who had once lost their accommodation, and this really puts the case management on a kind of break, because then for 2-3 months the focus is on finding new and stable accommodation, and all the other elements of the case management are put on hold. What we see, what I said already, is that unreturnability is really becoming visible. So we have to lobby also on the political level to find solutions for these families, but because there are no provisions in law. And I think one of the important learnings is that this case management really takes the imminent fear to be detained away, which makes space in the heads of people when they have to be less afraid of being detained. Just to conclude, as a final word, is that we of course are monitoring our project, and that we are registering both quantitative and qualitative data. Qualitative data, we will provide case studies in our report, and we will use this also in our discussions with politicians. We are not only looking to the result of the case resolution, but it's more important to look at the impact of the case management towards the well-being. If we can gain more trust, but if the families can gain more trust into the system, if they are more self-confident, if they do more comply with the system. And in Belgium, we are actually not the only ones working with this methodology. There are other NGOs who are actually inspired by the Dutch model. They don't link it with prevention of detention. It's more about getting undocumented migrants without shelter out of the streets of cities and putting them into shelters. But they're also providing case management in these shelters. So we are actually building a network, a national network of these NGOs, and we're sharing tools and experiences amongst each other. So yeah, that's actually more or less the evolution that we experienced in Belgium the last 3 years.